Article 8 of the model law is of particular importance. It provides for the enforcement of a valid arbitration agreement by referring the parties to arbitration. National courts are not permitted to entertain the substance of the parties' dispute, but instead must refer that dispute and the parties to arbitration for the arbitral tribunal to decide their dispute. Articles 10 through 15 deal with the appointment of arbitrators, the number of arbitrators and the means of both appointing and then challenging and removing those arbitrators. This is one of the limited but highly important roles that national courts play in the international arbitral process. Article 16 of the model law deals with the subject of jurisdiction, a highly important issue in international arbitration. Article 16, subparagraph 1, affirms the so-called separability presumption, the principle that arbitration agreements, even if included within a commercial contract, are nonetheless presumptively separable, autonomous from the underlying contract, treated in most respects as a separate contract, a separate agreement. Article 16, subparagraph 1 also recognizes the arbitrator's competence, the arbitrator's authority to consider and decide challenges to their own jurisdiction. Article 16, subparagraph 1, like most other national arbitration statutes, expressly recognizes the arbitrator's competence. Articles 16.2 and 16.3 then address procedures for jurisdictional challenges before the arbitral tribunal, as well as in Article 16, subparagraph 3, providing for judicial determinations of preliminary challenges to the arbitrator's jurisdiction, challenges to the existence, validity, or scope of an international arbitration agreement. Article 17 of the model law deals with provisional measures, also termed interim relief. Article 17 makes clear that national courts may grant provisional measures in aid of arbitration. Together, Articles 9 and 17 remove any doubts about the concurrent jurisdiction of national courts to grant provisional measures, at the same time that, in many instances, arbitral tribunals themselves may also do so. Articles 18 through 26 of the model law deal with the conduct of the arbitral proceedings. These include the selection of the language of the arbitration, the seat of the arbitration, and the procedures to be used in the arbitration. These articles, Articles 18 through 26, provide a basic set of procedural rules subject to a very limited number of mandatory principles of fairness, due process, and equality of treatment. Those mandatory principles are set forth in Article 18 of the UNCITRAL model law. Article 18 guarantees that in all circumstances the parties will be granted a full opportunity to be heard, to present their cases, and that they also will be treated with equality. Subject to these mandatory principles, Article 19 of the model law affirms the parties' procedural autonomy, the parties' freedom to agree upon the arbitration procedures to be used to resolve their disputes. Article 19, subparagraph 2, provides the arbitrators with broad, almost unfettered procedural discretion when the parties have not exercised their procedural autonomy. The parties' procedural autonomy on the one hand and the arbitral tribunal's procedural discretion on the other hand are subject only to the mandatory procedural guarantees set forth in Article 18 of the model law, the guarantees of equality of treatment and an opportunity to be heard. Article 27 provides for judicial assistance for evidence-taking in arbitration. National courts, in limited circumstances, may take evidence in aid of the arbitral process. Articles 20 through 26 deal with various procedural steps in the arbitration, including particular written submissions, the conduct of the evidentiary hearing and the party's right to an evidentiary hearing, the appointment of experts, including experts by the arbitral tribunal. Article 28 deals with the choice of the applicable substantive law by the arbitral tribunal. Parties are entitled, by virtue of their autonomy, to select the substantive law governing their dispute. But when they have not done so, Article 28 authorizes the arbitral tribunal to select an applicable substantive law. Articles 29 through 33 deal with arbitral awards, and in particular, the form of arbitral awards, the making of arbitral awards, including the availability of a majority award not agreed to by all arbitrators. Article 33 also deals with corrections and interpretations of arbitral awards by the arbitral tribunal after an award has been made. Article 34 deals with the setting aside or annulment of arbitral awards. Article 34 sets forth an exclusive, exhaustive list of the grounds for annulment. No other form of recourse against the arbitral award is available, save for the limited and exclusive grounds for annulment contained in Article 34. Articles 35 and 36 of the model law implement Articles 3, 4, and 5 of the New York Convention. They provide for the presumptive validity and enforceability of arbitral awards, including foreign arbitral awards. They also provide that arbitral awards may be denied recognition and enforcement in limited circumstances. Those circumstances, like the grounds for annulment in Article 34, are set forth exhaustively in Article 36 only if one of the grounds for non-recognition specified in Article 36 is satisfied, may an award be denied recognition. Article 34's grounds for annulment are highly important. They limit, again, like Article 5's judicial non-interference principle, the role of national courts in the arbitral process. Article 5 prevents national courts from intervening in the arbitral process prior to its conclusion. Article 34 then, at the conclusion of the arbitration, limits severely the grounds for a national court to set aside or annul an arbitral award. Article 34 provides that, apart from 6 specifically identified grounds for annulment, there is no recourse against an arbitral award. Those grounds for annulment are summarized on the current slide. They're limited to jurisdictional issues, either the lack of a valid arbitration agreement or an arbitrator's excessive authority exceeding the scope of a valid arbitration agreement. They also include procedural irregularities, either a denial of due process, equality of treatment, or the opportunity to be heard, or alternatively, the arbitral tribunal's failure to apply the arbitral procedures agreed to by the parties. Finally, awards may, in very limited circumstances, be annulled on the basis either of public policy or alternatively, the non-arbitrability doctrine, a rule that a limited set of disputes are not capable of settlement by arbitration. Articles 35 and 36 are broadly similar to Article 34. They're just the mirror image. Article 35 provides for the presumptive recognition and enforcement of international arbitral awards. Arbitral awards are presumptively final and binding, with res judicata and preclusive effects akin to those of national court judgments. Only where one of the list of narrow exceptions in Article 36 is present may an award be denied recognition. Only where an award debtor proves that one of the grounds for non-recognition, which include jurisdictional objections, procedural irregularities, and public policy. Only where one of these grounds is established by the award debtor may an award be denied recognition. Fundamentally important, neither Article 34 nor Article 36 permits either annulment of an arbitral award or non-recognition of an arbitral award after a review of the merits or substance of the arbitrator's decision. Annulment and non-recognition are not appellate proceedings. Annulment and non-recognition do not involve second-guessing the correctness of the arbitral tribunal's substantive decision. They are limited to inquiries into jurisdiction, procedural irregularities, and public policy. No substantive review of the arbitrator's decision is permitted. The original 1985 UNCITRAL model law was subsequently amended. It was subsequently amended in 2006 in limited respects. The principal amendments concerned Article 2, which added a general interpretive principle, requiring that courts interpreting the model law look to its international purposes. Additionally, Article 7, which addresses the written form requirement, the formal requirements for international arbitration agreements, was amended, primarily to reduce the form requirement. And third, the 2006 amendments to the original model law included much more detailed provisions regarding provisional measures, and in particular, the circumstances in which both national courts on the one hand and arbitral tribunals on the other hand could grant provisional measures. The revisions to Article 17 also included enforcement mechanisms for provisional measures that had been granted by arbitral tribunals. As we've seen previously, neither of these versions, the 1985 original version or the 2006 amended version of the UNCITRAL model law, has independent legal effect. The model law only has legal effect if it is implemented as a national statute in a particular jurisdiction. In fact, the model law has been used as the basis for national arbitration legislation in more than 100 jurisdictions around the world. These include, as we can see in the current slide, Australia, Bermuda, Bulgaria, Canada, Cyprus, Germany, Hong Kong, India, Singapore, various US, Canadian, and Australian states and provinces. A very substantial number of the most important jurisdictions in the world have adopted some version of the UNCITRAL model law. We can see on the current slide, for example, those states which have either adopted the UNCITRAL model law or modeled their national arbitration legislation relatively closely on the model law. Decisions by national courts applying the UNCITRAL model law on international commercial arbitration have begun to develop a reasonably extensive and reasonably consistent body of jurisprudence. These courts have looked to one another, to one another's interpretations of the UNCITRAL model law, as well as interpretations of the New York Convention in dealing with disputes arising under the model law. Several transnational databases focused on UNCITRAL model law decisions have been developed. The UNCITRAL Clout database is a system for collecting information on court decisions and arbitral awards relating to all the UNCITRAL conventions and model laws, including the UNCITRAL model law on international commercial arbitration. The McGill Model Arbitration Law database includes similar information, decisions by national courts applying the UNCITRAL model law. You can see these websites and the web addresses needed to access them on the current slides. It's important also that national courts in interpreting the model law have looked to the New York Convention. We can see one example of this in an Australian High Court decision, which held that so much of the text of the model law has its origin in the New York Convention that it should be construed in the context and in the light of the object and purpose of the New York Convention. That analysis is precisely correct. The model law was intended specifically to implement the New York Convention, in particular Articles 2, 3, 4, and 5. It's entirely appropriate, therefore, as national courts have done, not just to look to one another's decisions applying the model law and interpreting it, but also applying and interpreting the New York Convention. National court decisions in jurisdictions around the world have given rise to a body of international common law dealing with international commercial arbitration. That body of common law contributes to the efficacy of the New York Convention on the one hand, the UNCITRAL model law and other supportive national arbitration legislation on the other hand. That precedent from states around the world is truly international. It learns from, builds upon, develops international authorities from other jurisdictions, both as a matter of binding international law under the New York Convention and as a matter of national law, interpreting national enactments of the UNCITRAL model law and other national arbitration legislation. There is a second category of national arbitration legislation. In addition to national arbitration legislation that is supportive of the international arbitral process, there's national arbitration legislation that is not supportive or that is less supportive of the arbitral process. Some nations, particularly in the 19th and early 20th century, regarded international arbitration, both state-to-state investment and commercial arbitration, with a mix of mistrust, suspicion, and sometimes outright hostility. This hostility was often based on notions of state sovereignty, concerns that international arbitration eroded state sovereignty and state regulatory authority. For the most part, these suspicions, this mistrust has evaporated. For the most part, states, particularly where international commercial arbitration is concerned, have put to one side these concerns about the international process, have concluded that the process produces efficient, expert, even-handed, and enforceable decisions which facilitate international trade and commerce in an open and even-handed manner. Nonetheless, historically, some states, particularly in Latin America, the Middle East, some parts of Africa, regarded international arbitration agreements as threats to state sovereignty. They refused to recognize or enforce international arbitration agreements, particularly as applied to future disputes. States took the position that these types of agreements eroded or threatened state sovereignty, state control over all matters of life within their borders, and thus that international arbitration agreements were invalid and unenforceable. The Calvo Doctrine in 19th century Latin America was a good example of one type of thinking along these lines. The Calvo Doctrine declared that foreign nationals, foreign investors in particular, were mandatorily subject to the jurisdiction of local courts in the host state. That jurisdiction could not be ousted by arbitration agreements. Arbitration agreements, as a consequence, particularly agreements to arbitrate future disputes, were per se unenforceable. A decision of the Andean Commission, decision number 24 from 1971, is a good example. It provided that no agreement concerning foreign investment shall withdraw possible controversies from the national jurisdiction of the recipient country, a broad anti-arbitration rule that denied recognition and enforcement to a large category of international arbitration agreements. In other jurisdictions, arbitration legislation sometimes did not provide for the effective enforcement of agreements to arbitrate future disputes, as distinguished from submission agreements with regard to existing disputes. Until recently, for example, the Argentine National Civil and Commercial Procedural Code arguably required a post-dispute compromis. Agreements to refer future disputes, which did not yet exist, were invalid, could not be recognized and enforced. More recent enactments, the new Argentine National Civil and Commercial Procedural Code, appears to have eliminated this requirement and to have brought Argentina into step with most other developed states around the world. In a few states, arbitral awards are subject to either de novo judicial review or to similarly rigorous scrutiny on other grounds, sometimes on some public policy theory. We can see examples of this on the current slide. Alternatively, in a few states, national arbitration legislation prescribes or is interpreted to prescribe detailed and somewhat formulaic procedural requirements for the arbitral process, or alternatively, mandatory procedural timetables or schedules for the arbitral process. In some cases, mandatory procedural steps in the arbitral process, none of which, in most cases, accords with the parties' expectations or intentions. Despite national arbitration legislation or national court decisions which either denied effect to international arbitration agreements or denied effect to international arbitral awards, during the past 20 years, states that once distrusted international commercial arbitration have taken a different view. Those same states have ratified the New York Convention and, in many circumstances, enacted pro-arbitration legislation, often modeled on the UNCITRAL model law on international commercial arbitration. States which fall into this category include India, China, Saudi Arabia, Algeria, Bahrain, Brazil, Colombia, Tunisia, Turkey, Nigeria, Peru, Russia, and, at least for a time, Argentina, Ecuador, and Venezuela. All of these states ratified the New York Convention. All of these states adopted arbitration legislation that gave effect to international arbitration agreements and arbitral awards. National courts in some jurisdictions continue to resist these steps towards international arbitration, making international commercial arbitration part of each nation's framework for resolving international disputes. National courts will interpret the provisions of national arbitration legislation narrowly or in ways that fail to give effect to the objectives of the New York Convention or the model law. Nonetheless, the decided trend, the overwhelming trend over the past 30 years has been towards national arbitration legislation that is supportive of the arbitral process, that faithfully implements the New York Convention, and in particular, Articles 2, 3, 4, and 5